speaker for this session is Professor Dr. Ricky J. Lee. Dr. Lee is an international academic and commercial lawyer specializing in the aerospace industry, having acted for and advised government agencies, launch providers, and satellite operators in over 2 decades of private practice. He has taught space law at universities since the year 2000 and holds a PhD from Murdoch University and an LLM from the Australian National University. Dr. Lee is an Intellectual Forum Senior Research Associate of Jesus College, Cambridge, Adjunct Professor of Law at Nirma University, India, and Adjunct Professor of Law, University of Notre Dame, Australia. He is a Fellow of the Australia and New Zealand College of Notaries, the Commercial Law Association of Australia, the Royal Society for the Arts, Manufactures and Commerce, and the International Association for the Advancement of Space Safety. He has published over 150 books, chapters, articles, and papers, and has presented frequently at international conferences and workshops. We welcome you, sir, to the session.
Thank you very much, and thank you for both your kind invitation and that lovely introduction. Good afternoon, and thank you. Certainly an honor for me to address this large gathering. I'm very honored to join my colleagues in making this presentation. I'm aware that we are running out of time, and I'm the only thing standing between you and the lunch break, so I'm going to speak for as long a time as I possibly can. So I'd like to apologize for that in advance, knowing that you're going to be starving. My topic today is the ongoing debate as to the status of space tourists as astronauts. There has been a significant amount of debate, both in academic circles as well as within legal subcommittee and other policy setting forum, as to whether private individuals who travel to space, as in not being part of a government program, should be regarded as astronauts. The idea of sending private individuals, as in non-professional or amateur astronauts, so I don't want to put it that way, into space is not a new phenomenon. People often refer to Dennis Tito in the beginning of this century as being the first space tourist, and that's probably correct. But at the same time, as early as 1985, NASA was already sending people who are not professional astronauts into space on board the space shuttle. That, of course, ended after the Challenger accident in 1986. Throughout the first 2 decades of this century, as well as the end of the last century, NASA, Roscosmos, the Russian space agency, as well as the Federal Aviation Administration, or the FAA of America, have all referred to these non-governmental, or what they call non-professional spacefarers, as spaceflight participants. And so they go into space, but they're not regarded as professional astronauts. So as a policy standpoint, they regard astronauts as those who are professionally trained and go into space as part of a government directed and managed space program. That's not to say that there have been government space programs that sent humans into space, and therefore they're all astronauts. For example, the Korean astronaut program, which was an arrangement between Russia, the ISS partners, and South Korea, whereby South Korea paid for a launch spot for one of their nationals to go into space. And that happened in 2007. Even though it is a government space program for the purposes of South Korea, nevertheless, she was not classified as an astronaut for either Roscosmos or NASA purposes. She was referred to as a spaceflight participant. So you could be very well trained, you could be government appointed, you could be on the government payroll, and yet they still don't refer to them as astronauts. In essence, it means that from a policy standpoint, they consider astronauts as those who actually make a career out of being an astronaut and going to space as part of that profession. And if there was already some discussion as to what being an astronaut means for private spacefarers, the billionaire space race that took place last year with the likes of Richard Branson and Jeff Bezos going into space further posed at least a publicity challenge, if not a legal challenge, to their status as astronauts. The essence of my presentation today, and I am going to do the lawyer thing of referring to a number of treaties and a number of provisions in relation to the classification of spacefarers, as well as analogies by sea and by international aviation. The crust of my presentation today revolves around the hypothesis that I want to state right at the outset, which is that this is a debate that's completely irrelevant as a matter of law, because while having the title of an astronaut might sound good, in fact, it is devoid of any practical legal effect. And I hope to spend the next 12 minutes or so going through the bases by which I justify that proposition. To start with, I want to refer to the only treaty provision in existence that uses the term astronaut, and that is found in the 1967 Outer Space Treaty, in which Article 5 talks about state parties shall regard astronauts as envoys of mankind and are to render to them any possible assistance in the event of accident, distress, or emergency. If astronauts return to Earth because of accident, distress, or emergency, they have to be returned immediately to the state that their space vehicle is registered. And astronauts of one state are supposed to render all possible assistance to astronauts of other states. There is nothing in Article 5 that actually defines the term astronaut. So while we have spent, along with the previous slide, talked about how astronauts are regarded from a policy standpoint as being those who carry on being an astronaut as a profession, there is no such requirement and no such distinction between amateur astronauts and professional astronauts in the Outer Space Treaty. For all intents and purposes, the Outer Space Treaty regards anybody as astronauts, or you may say they left astronauts to be defined by the states themselves, because you've got to remember in 1967, only the Americans and the Soviets were sending people into space, and they were only doing so as part of an official designated government program. The rescue agreement, which came in 1968, don't talk about astronauts, but they do carry forward or expand on the obligations that you find in Article 5 of the Outer Space Treaty. For example, Article 2 of the Rescue Agreement talks about states taking all possible steps to rescue and render all necessary assistance to spacefarers that have returned to Earth. But the description that is given to those crews is personnel of a spacecraft. There's no use of the term astronaut. There is mention of the term astronaut in the preamble of the rescue agreement, but the operative provisions of the rescue agreement don't use the term astronaut at all. They use the term personnel of a spacecraft. And just quickly looking at the other relevant provisions of the rescue agreement, we see that, again, the use of the descriptor personnel of a spacecraft is consistent throughout the other provisions of the rescue agreement. The Article 3 of the rescue agreement talks about rendering assistance in the high seas or any other area that is not under any sovereign state's jurisdiction to provide assistance in search and rescue operations to personnel of a spacecraft. In Article 4, talks about accident, distress, emergency on the high seas or in any place not under sovereignty. They are to be rescued and promptly returned to the launching authority of their spacecraft. And again, the them here is to use their term personnel of a spacecraft. going more holistically at the treaty for a moment, the Outer Space Treaty talks about astronauts, but the rescue agreement talks about personnel of a spacecraft. Which one is going to apply? Well, for starters, let's look at how many states are parties to the treaties. There are 98 state parties to the rescue agreement out of 193 United Nations member states. There are 98 states to the rescue agreement, and all 98 are state parties to the Outer Space Treaty. There are 13 state parties to the Outer Space Treaty that are not party to the rescue agreement. So how does that work in terms of distinguishing between the obligations under Article 5 and the obligations under the rescue agreement? Well, the Vienna Convention on the Law of Treaties, Article 30, paragraph 3, says that if there is two treaties, one earlier, one later, and they cover the same subject matter, then either you comply with both, or if it is not practicable to comply with both, then you comply with the later one. Now, the rescue agreement came later. So if there is an argument that, well, the rescue agreement is inconsistent with the Article 5 of the Outer Space Treaty because it uses different terms, then to the extent there is an inconsistency, you follow the rescue agreement. But I would say that regardless of how you define astronaut, the definition and scope of personnel of a spacecraft has to be broader. And so in that context, it is possible to comply with both. You just comply with the broader terms of the rescue agreement. And in doing so, you would also have complied with the Outer Space Treaty. So in either case, for the 98 states that are parties to both, it would be the rescue agreement and the broader scope of the personnel of a spacecraft that's going to be the prevailing definition as far as their obligations is concerned. For the 13 states that are party to the Outer Space Treaty, but not the rescue agreement, of course, the rescue agreement doesn't apply to them. Arguably, it is the Outer Space Treaty that applies to them by operation of Article 30, paragraph 4 of the Vienna Convention. There are some scholars who have commented on the extent to which the obligations of the rescue agreement have crystallized into customary international law so that they are binding on all states regardless of whether they're party to the rescue agreement or not. In practice, it really doesn't matter because every state that has sent humans into outer space and every state that so far have taken practical and technical steps towards sending people into space are all parties to the rescue agreement. So in that context, it really doesn't matter. The rescue agreement is going to apply. The provisions in the rescue agreement don't talk about astronauts. They talk about personnel of a spacecraft. And in that context, of course, it covers both professional astronauts as well as private spacefarers who go into space for whatever reason, be they tourists, be they employees, or be they flight crew. This is also consistent with the analogous provisions that can be found in international law dealing with maritime rescue as well as aviation rescue. Let's first of all look at rescue at sea, and I apologize for the typo. The duty that states have to attempt rescue of persons at sea is found both in the UN Convention on the Law of the Sea in Article 98 and the SOLAS Convention, which is the Convention for the Safety of Life at Sea, Regulation 533. Both of these provisions are very broad in their application, as we will look at one by way of an example in a minute or so. There's also an international legal duty to organize and coordinate search and rescue operations. That can be found under the International Convention on Maritime Search and Rescue, Article 2.3, and also in SOLAS in Regulation 5.7. The European Court of Human Rights has also held that there is an international legal duty to take care of rescuees once they are rescued from vessel or once they are rescued from the sea. As I foreshadowed, let's have a look at the primary provision that carries forward a duty to rescue people in distress at sea, and that's found in Article 98 of UNCLOS. There is no use of the term seafarers in an analogous way to the use of astronauts in the Outer Space Treaty. Article 98 simply uses the term any person found at sea. So every state has to render assistance to any person found at sea in danger, proceed with all possible speed to the rescue of persons in distress. No qualifying requirement that those persons be professional seafarers or otherwise. And after any collision, they have to render assistance to the other ship, its crew, and its passengers. So there may be a technical distinction between crew and passengers, but that's only really to avoid the concept that you have to rescue the passengers being innocent civilians, but the crew should be able to take care of themselves. Well, if you look at subparagraph A, well, there is still the obligation to render any assistance. And under subparagraph B, also to proceed with all possible speed to their rescue and assistance. So in that context, there's really no professional distinction. So there's really no legal distinction between a professional seafarer and, say, a civilian passenger. When we look at civil aviation, we see a similar broad scope in the duty to rescue and render assistance. The Chicago Convention on International Civil Aviation, Article 24, requires each contracting state to provide such measures of assistance to aircraft in distress in its territory as is found practicable. To expand further on this obligation, as well as to extend the search and rescue obligations to also cover areas over the high seas, Annex 12 to the Chicago Convention contains standards and recommended practices, or SARBs, on the organization and operation of these search and rescue operations. And in Annex 12, it uses the term persons in distress as the object of these search and rescue operations. Again, there's no distinction between flight crew and passengers. There's no distinction between professional aviators and passengers or civilians. It's simply a broad, any person in distress is the object of these international legal obligations to do with civil aviation. So the conclusion I would draw is as follows. The rescue agreement is, when we look at it in this context, is perfectly consistent with existing obligations that exist under international law for rescue at sea and rescue from civil aviation. It doesn't use the term astronaut. So as such, just because we may not get to call them astronauts as a matter of law, doesn't mean that private spacefarers suffer from any legal deficiency simply because they are space tourists or simply because they are employees or engaged in any private manner during their activities in outer space. So my suggestion to you and for any children in the future is that instead of narrowing their scope and say, well, when I grow up, I want to be an astronaut, what they really should say is, when I grow up, I want to be a spaceflight participant. So that way they also won't need to ask the question, well, what makes an astronaut? I know I went through that a bit too quickly. I do so only because of recognition of our limited time. So I want to thank you very much for your time.